Hello, everyone. I have so I've got two letters I wanted to just quickly go through as well. And then I'm probably gonna like get off here for the rest of the day. I'm gonna go spend more time going through the exhibits, I think, and categorizing them, working out a system for how to cover them. I want to go through two letters. The first one here is from Jed Wallace. Okay, so we write on behalf of non-parties Jed Wallace and Street Relations. I'm so happy to see him writing and referring to himself as a non-party. Regarding plaintiff Blake Lively's motion to compel Wayfarer parties to produce documents withheld on privilege grounds. So this argument that's been going back and forth over privilege logs, etc. And Lively filing a motion to compel months after the end of discovery. Lively previously filed similar motions seeking orders compelling non-parties Brianna Coslow and Katie Case to produce documents withheld on privilege grounds. The court entered an order granting in part and denying in part the motions, and the Wallace non-parties, who were parties at the time, thereafter filed a letter motion seeking reconsideration of the court's order to the extent it implicated the Wallace non-parties' privileged communications. The court granted the Wallace non-parties' motion for reconsideration, and after considering privilege logs submitted by both Wayfarer parties and Wallace non-parties, entered an order on the privilege assertions. In her motion, Lively again seeks production of documents and communications withheld on privilege grounds and identified on the Wayfarer parties' privilege log, including numerous documents and communications by or including Wallace. Though no longer parties to this litigation, the fact remains that the Wallace non-parties were clients of Lyman, Friedman, Tettleman, and Cooley. That's Friedman's firm, under the terms of an engagement letter entered December 24, 2024. Communications amongst and between the Wallace non-parties, the Wayfarer parties, and LFTC are protected by attorney-client privilege. The Wallace non-parties have not and do not waive that privilege, and this court has already recognised the existence of privilege and the proper withholding of documents and communications amongst and between the Wallace non-parties, the Wayfarer parties, and LFTC. The Wallace non-parties therefore ask the court to enter a protective order against the disclosure of those privileged communications. Footnote: the relief sought is not intended to and does not waive the Wallace non-parties' jurisdictional objections raised in their now granted motion to dismiss Lively's second amended complaint. Rather, the Wallace non-parties seek the requested relief to protect the privilege held and, importantly, never waived by Wallace and Street. So that's pretty self-explanatory. She's trying to compel documents from Wayfarer. Wayfarer saying these documents are privileged, and some of those documents include Jed Wallace, who was a client of Friedman. And he's saying, well, hold on a minute, I'm not waiving my right to privilege either, because I was a client of Friedman. Okay, so see what Lively says. I'm just going up to the top of this ridiculous, heavily burdened docket. Okay. This is just one page, so I'll cover this as well, actually. It's an order from Judge Lyman. And it says, the court has before it the motions for summary judgment and the opposing papers. Given the number of exhibits filed under seal and limitations with the electronic court filing system's treatment of such materials, the court requests that the parties, 1, email to the court electronic unredacted versions of the exhibits. The parties can simply forward to the court the exhibits to the extent they were already served electronically by email on opposing counsel. And 2, hand-deliver to the court physical paper copies of the unredacted materials and supporting declarations and exhibits. The parties are requested to do the same with respect to the forthcoming reply briefs and the materials regarding the motions for spoliation sanctions. So these motions are so heavy and have got so many exhibits attached to them. The court is saying, the electronic court filing system is limited. Can you please provide these in this alternative way? And the exhibits are huge. Like, it's going to take quite a while to get through them all. And I do intend to cover them all in full. I don't believe in just picking out little bits that I find fascinating or always a little bit of tea. That's important and part of the fun, but this is a lawsuit, and everything needs to be looked at. Okay, and now we have Wayfarer's response. Now, I don't know if you remember, Lively tried to supplement her Rule 11 sanctions. Those are the sanctions for Friedman's statements. She tried to supplement that. Wayfarer have responded. Lyman said, yeah, you can respond. So they've responded. So here is that response. Dear Judge Lyman, on behalf of the defendants of Wayfarer, etc., we submit the supplemental opposition to Blake Lively and Ryan Reynolds' request for leave to supplement their respective Rule 11 motions, pursuant to the court's November 20th, 2025 order. Lively and Reynolds seek to supplement their fully briefed Rule 11 motions with deposition testimony from Steve Sarwitz and Jennifer Abel that, at the time the Wayfarer parties filed their complaint, Abel and Sarwitz lacked personal knowledge for the basis for the extortion, intentional interference, and or breach of the implied covenant of good faith and fair dealing claims, as well as the defamation claim against Reynolds. Primarily, Lively and Reynolds conveniently failed to note that Abel and Sarowitz's testimony came on the heels of attorney-client privilege objections and instructions not to respond with information learned exclusively through communications with counsel. Oh, of course they omitted stuff, irrelevant details. Of course they did. When pressed and struggling to respond without divulging attorney-client communications, Abel and Sarowitz attempted to respond based on their personal knowledge, excluding any information or knowledge obtained through counsel or counsel's reasonable investigation. This omission alone undercuts any potential value of the testimony to the court's Rule 11 analysis. This is only one of multiple reasons why Lively and Reynolds' request to supplement their Rule 11 motion should be denied. To start, Lively and Reynolds do not cite any authority for the notion that a pending fully briefed Rule 11 motion can be supplemented with additional evidence. Neither decisional authority, the express language of Rule 11, nor Rule 11's advisory committee notes permit or prescribe supplemental evidence or submissions. However, at least one district court has found that corroborating testimony is not proper to supplement previously submitted evidence. And then they cite that case. Okay, so the case is Joint Stock Company Channel 1 Russia Worldwide against Informir LLC. And the comments in that case are they declined basically to supplement Rule 11 motion with deposition testimony that merely corroborated evidence already before the court. In fact, Rule 11 discovery is disfavored and Rule 11 motions are typically confined to the record. Thus, discovery should be conducted only by leave of the court and then only in extraordinary circumstances. Based on this principle, district courts routinely deny requests for Rule 11 discovery. The testimony that Lively and Reynolds would like the court to consider merely corroborates evidence already submitted in support of their original Rule 11 motions. The testimony is the product of discovery solely directed to the Rule 11 motions. Wayfarer's complaint was dismissed on June 9, 2025, obviating any need for discovery relating to Wayfarer's claims. Therefore, whether Abel or Sarowitz lacked proper grounds to assert the dismissed claims is irrelevant to Miss Lively's pending affirmative claims, and the only purpose of this line of deposition questioning was to obtain discovery to support Lively and Reynolds' Rule 11 motions. Oh. Oh dear. Lively and Reynolds, however, did not seek leave to conduct Rule 11 discovery, another reason why their request to supplement should be denied. Next, whatever their testimony, Abel and Sarowitz's conduct belies any notion of bad faith. After the Rule 11 motions were fully briefed, the court granted Lively and Reynolds Rule 12b6 motions, dismissing Wayfarer's complaint in its entirety. The motions to dismiss raised precisely the same issues identified as the basis for Lively and Reynolds' Rule 11 motions. Wayfarer's intentional interference and breach of the implied covenant of good faith and fair dealing claims, a primary focus of their Rule 11 motions, were dismissed with leave to amend. At the outset, the dismissal of a claim does not translate to the extreme bad faith required to justify Rule 11 sanctions. Moreover, Abel and Sarowitz elected not to amend the intentional interference and breach of the implied covenant claims, allowing them to be dismissed as demanded in Lively and Reynolds' Rule 11 notice letters. While it is true that the claims were not dismissed within Rule 11's 21-day safe harbour period, the pleading defects, which are the basis for Lively and Reynolds' Rule 11 motions, were already before the court in the pending motions to dismiss. We've got a footnote. The claims were asserted by a group of all plaintiffs, not merely Abel and Sarowitz. Lively and Reynolds' motions to dismiss were based in large part on group pleading, a common pleading defect which does not warrant Rule 11 sanctions. In the same vein, that fact that Abel and Sarowitz were not properly grouped with the other plaintiffs because they had no factual basis for the claims does not translate to a finding that the claims were not validly asserted by other plaintiffs. Sarowitz and Abel had every right to wait for the court's ruling on these issues. Abel and Sarowitz's decision not to amend once the court found the pleading deficient hardly indicates bad faith. To the contrary, Abel and Sarowitz substantially complied with the Rule 11 letters. Any deficiency in timing is attributable to Lively and Reynolds jumping the gun to file premature Rule 11 motions. In short, Abel and Sarowitz's voluntary decision to withdraw the claims had precisely the same result sought by Lively and Reynolds' Rule 11 notice letters. Lively and Reynolds also failed to show that Abel and Sarowitz's testimony is in any way material to the court's Rule 11 analysis. In contrast to attorneys, parties such as Abel and Sarowitz cannot be sanctioned for legally frivolous claims, but may be sanctioned for totally meritless factual allegations. Okay. First, Abel and Sarowitz's personal understanding of the basis for their legal claims should be placed in the context of the attorney-client objections, instructions not to answer, and responses indicating that the questions could not be answered without disclosing privileged information. Second, neither Abel nor Sarowitz is a lawyer, and their personal knowledge of what facts constitute a legal claim is not relevant to a Rule 11 analysis. Third, and most significantly in their testimony, neither Abel nor Sarowitz identify a false or fabricated fact or a fact utterly lacking in support. Rather, the sum and substance of their testimony is that, other than through communications with counsel, they did not know or understand the underlying basis for the legal claims asserted on their behalf in the Wayfarer complaint. And Lively and Reynolds overlook and ask this court to overlook that Rule 11 sanctions are not appropriate where there is good faith belief that discovery will yield evidence to support a claim. Here, as noted in Abel and Sarowitz's opposition, discovery has, in fact, yielded evidence of defamation by Reynolds, which was not in their or Wayfarer's possession at the time the Wayfarer complaint was filed. Oh. Oh, that's interesting. In short, Abel and Sarowitz's testimony is insufficient to establish that counsel, the certifying party, lacked a good faith basis for the claims, or that Abel or Sarowitz communicate to counsel that they did not know or understand the factual basis for their claims. Abel and Sarowitz's liability under Rule 11 is derivative of counsel's violation. Without a showing that their counsel violated Rule 11, sanctions cannot be imposed against Abel or Sarowitz, regardless of their understanding of the basis for the claims in which they were grouped as plaintiffs. For the foregoing reasons, the Wayfarer parties respectfully request the court enter an order denying Lively and Reynolds' request to supplement their Rule 11 motions. Well, a couple of things. One, so now there's evidence of defamation by Ryan Reynolds. Also, Blake Lively's counsel misrepresented information and statements. This is not shocking. She did it to us content creators too. So, all right. Yeah, I think that's me done for today. I will be back probably tomorrow with something, some of the exhibits. I'm also going to do a read-through. It will be a long video, but I'm going to do the read-through of the 250-page filing by President Macron and his wife, the French president and his wife, against Candace Owens. So I'm not taking a side on it. I read it the other day and it was absolutely fascinating, actually. So I just think it's something that is worth, having a read through and a little chat about. I'm hoping to do that either Saturday or Sunday, if I can fit it around my little one. But it will be a long video. I can't make that shorter. I will probably do the full read through though, and then do a shorter summary as I usually do for long videos. I'm hoping to get that done though, Saturday or Sunday. So yeah, it'd be nice if you guys could join us. All right, take care.